Good day, everyone. We will be discussing Unit 9, the legal aspects of product protection. First, we will introduce Republic Act Number 8293, or the Intellectual Property Code of the Philippines. This is an act prescribing the Intellectual Property Code and establishing the Intellectual Property Office, providing for its powers and functions and for other purposes. This act shall protect and secure the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creations, particularly when beneficial to the people, for such periods as provided in this act. So what are intellectual property rights? These are like any other property right. They allow creators or owners of patents, trademarks, or copyrighted works to benefit from their own work or investment in a creation. These also provide for the right to benefit from the protection of moral and material interests resulting from authorship of scientific, literary, or artistic productions. Intellectual property rights are the rights given to persons over the creations of their minds. So they usually give the creator an exclusive right over the use of their creation for a certain period of time. So the term intellectual property rights consists of copyright and related rights, trademarks and service marks. So trademarks is specifically a creation to identify a business product. So a trademark can be any word, name, symbol, or device, or any combination which is used or intended to be used to identify and distinguish the goods of one company from those of others. So a service mark, on the other hand, is the same type of device as a trademark, but service marks distinguish the services of one company from those of another provider. So service marks are often slogans. For example, the generics pharmacy service marks is Tagapagpagaling ng Pilipinas. So intellectual property rights also consist of geographic indications. Examples of these are Davao Pomelo, Bicol Pili Nut, Guimaras Mangoes, and Kalinga Coffee. It also has industrial designs, patents, layout designs or topographies of integrated circuits, and protection of undisclosed information. Ito yung trade secrets, which we will discuss in a bit. We will be focusing our discussion on these four types of intellectual property: the trade secrets, trademarks, copyrights, and patents. Trade secrets. A trade secret consists of any type of information, including a formula, pattern, compilation, program, device, methods, techniques, or process that derives independent economic value from not being generally known to other persons who can obtain economic value from its disclosure or use. The scope of protection available for trade secrets may be defined by a particular contract or fiduciary relationship, as well as by state statutes and court decisions. So in short, ang trade secrets ay mga confidential information na dapat ang company lang ang nakakaalam. These could be formulas, mga patterns, devices, or compilations of information na ginagamit sa business na nagbibigay ng advantage sa company against sa competitors nila. So, hindi dapat yun ma-disclose kasi nga advantage yun ng company. So, examples ng trade secrets ay mga business and strategic plans, mga research and testing data, customer lists, mga manufacturing processes, pricing methods, and marketing and distributing techniques. Unlike patent rights, trade secret rights have an indefinite lifespan so long as they are not terminated by public disclosure. So in order to establish a trade secret, one must show that information is not a matter of common knowledge in the industry. Reasonable precautions have been taken to maintain secrecy, and it is of some value. So other examples are formulas for medicines, such as hair conditioner and liniment, process kung paano mag-manufacture ng gas, permeable polymer for use in soft contact lenses. The next is trademarks. A trademark is a sign capable of distinguishing the goods or services of one enterprise from those of other enterprises. Trademarks date back to ancient times when artisans used to put their signature or mark on their products. Trademarks may be one or a combination of words, letters, and numerals. They may consist of drawings, symbols, or three-dimensional signs, such as the shape and packaging of goods. There are also countries na pwedeng mag-register ng non-traditional marks like distinguishing features such as holograms, motion color, and non-visible signs for like sound, smell, or taste. Trademark protection ensures that the owners of marks have the exclusive right to use them to identify goods or services, or to authorize others to use them in return for payment. The period of protection of trademarks varies but can be renewed upon payment of the corresponding fees. Trademark protection is legally enforced by courts that, in most systems, have the authority to stop trademark infringement. Trademark protection also hinders the efforts of unfair competitors, such as counterfeiters, to use similar distinctive signs to market inferior or different products or services. The system enables people with skill and enterprise to produce and market goods and services in the fairest possible conditions, thereby facilitating international trade. In the Philippines, a trademark can be protected through registration, but the trademark protection granted by IP Philippines protects your mark only in the Philippines. So if you want to protect your trademarks outside of the country, you would need to register it to other countries. Marks and indications that have become common in everyday language or usage cannot be registered. They no longer distinguish the goods and services because they are used so often to refer to the goods and services. Example of this is the VCO for virgin coconut oil and Diamond Bill for services involving cosmetic procedures. What are the requirements to apply for registration for trademarks? Number 1, a duly filled out request for registration, a drawing of the mark, and payment of fees.
Next is copyrights. Copyright is a legal term used to describe the rights that creators have over their literary and artistic works. Works covered by copyright range from books, music, paintings, sculpture, and films, to computer programs, databases, advertisements, maps, and technical drawings. Copyright laws grant authors, artists, and other creators protection for their literary and artistic creations, generally referred to as works. Original work refers to every production in the literary, scientific, and artistic domain. So, copyright is a legal means of protecting an author's work. It is a type of intellectual property that provides exclusive publication, distribution, and usage rights for the author. The creators of works protected by copyright and their heirs and their successors, generally referred to as right holders, have certain basic rights under copyright law. They hold the exclusive right to use or authorize others to use the work on agreed terms. Similar rights of, among others, fixation and reproduction are granted under related rights. Many types of works protected under the laws of copyright and related rights require mass distribution, communication, and financial investment for their successful dissemination. So, copyright provides authors and creators of original material the exclusive right to use, copy, or duplicate their material. A copyright also states that the original creators can grant anyone authorization through a licensing agreement to use the work. The works covered by copyright protection under the Intellectual Property Code. Section 172 of the Intellectual Property Code lists the works covered by copyright protection from the moment of their creation, namely books, pamphlets, articles, and other writings, periodicals and newspapers, lectures, sermons, addresses, dissertations prepared for oral delivery, whether or not reduced in writing or other material form, letters, dramatic or dramatico-musical compositions, choreographic works, or entertainment in dumb shows. musical compositions with or without words, works of drawing, painting, architecture, sculpture, engraving, lithography, or other work of art, models or designs for works of art, original ornamental designs or models for articles of manufacture, whether or not registrable as an industrial design in other works of applied art, illustrations, maps, plans, sketches, charts, and three-dimensional works relative to geography, topography, architecture, or science. Drawings are plastic works of scientific or technical character, photographic works including works produced by a process analogous to photography, lantern slides, audiovisual works and cinematographic works and works produced by a process analogous to cinematography or any process for making audio visual recordings, pictorial illustrations and advertisements, computer programs, other literary, scholarly, scientific, and artistic works. So those I have mentioned are the works covered by copyright protection under the Intellectual Property Code. So for example, sa book, di ba usually makita nato sa book or especially ka mga academic books nga ang page ana is na ay symbol nga C or kanang letter C which naga-indicate siya nga copyrighted na siya na book or covered by copyright protection under the Intellectual Property Code. Meaning pud ana is ang owner or ang author mismo is gina-authorize ni ang others nga i-reproduce iyahang work or iyang book or pwede po ibaligya, i-distribute or i-commercially exploit unless naghatag siya permission sa other people. So, ang owners mismo na sila ability to decide how and when others may use their works or their book. So, other example is kanang music. Na magoy ubang YouTube channel or dili lang sa YouTube pati pud sa Facebook na mag-re-upload sila og kanang music video god tapos walay consent or permission from the rightful copyright owner. So kana ilang gi-upload is pwede ma-report or pwede pud sila kasuhan jud mismo kay ang copyright infringement is punishable man siya by imprisonment ranging from 1 year to 9 years. And a fine ranging from 50,000 pesos to 1,500,000 pesos depende sa value sa infringing materials or ilang damage to the copyright owner o sa number of offenses committed. What is the term of protection of copyright? In general, the term of protection of copyright for original and derivative works is the life of the author plus 50 years after his death. The code specifies the terms of protection for the different types of works. In calculating the term of protection subsequent to the death of the author shall run from the date of his death or of publication, but such term shall always be deemed to begin on the first day of January of the year following the event which gave rise to them. So, ang duration sa copyright protection. So, sa Philippines, ang copyright protection for artistic, literary, and derivative works, nagalast siya during the lifetime of the author, plus 50 years after the author's death. What constitutes infringement? Copyright infringement consists in infringing any right secured or protected under the code. It may also consist in aiding or abetting such infringement. The law also provides for the liability of a person who at the time when copyright subsists in a work has in his possession an article which he knows or ought to know to be an infringing copy of the work for the purpose of selling or letting for hire or by way of trade, offering or exposing for sale or hire the article, distributing the article for the purpose of trade or for any other purpose to an extent that will prejudice the rights of the copyright owner in the work or trade exhibit of the article in public. So those I have mentioned were considered as the infringement or copyright infringement. So what are the requirements for the copyright registration? The application must contain the following: a duly accomplished form in duplicate for each work, provided that a separate application is submitted for each number of a periodical containing a notice of copyright. A supporting document evidencing ownership of the copyright, the manner of its acquisition, if the claimant is not the original author, translator, or editor, and where and in what establishment the work was made, performed, printed, or produced, in the date of its completion, and publication. Receipts showing payment of the registration fee if the application is filed personally or by postal money order if the application is filed by registered mail. Documentary stamps in the correct amount which shall be affixed to the registration and deposit certificate. Two complete copies of or reproduction of the work or replica or picture. 2 printed copies with the copyright notice printed in front or at the back of the title page or on any conspicuous space for a non-book material if the work is a published work. If the work is in a musical work, 2 copies of the original work in the form of a music sheet, in a cassette, optical disc, or multimedia. A technical description of the design if the work is an original ornamental design. 2 duplicate originals or certified true copies of the deed of assignment.
Patents. A patent is an exclusive rights granted for an invention. A patent provides patent owners with protection for their inventions. Protection is granted for a limited period, generally 20 years. Patents provide incentives to individuals by recognizing their creativity and offering the possibility of material reward for their remarkable inventions. Patent protection means an invention cannot be commercially made, used, distributed, or sold without a patent owner's consent. What rights do patent owners have? A patent owner has the right to decide who may or may not use the patented invention for the period during which it is protected. Patent owners may give 5 permissions to or license other parties to use their inventions on mutually agreed terms. Owners may also sell their inventions' rights to someone else, who then becomes the new owner of the patent. Once a patent expires, protection ends and the invention enters the public domain. This is also known as becoming off patent, meaning the owner no longer holds exclusive rights to the inventions and it becomes available for commercial exploitation by others. A patent is a grant issued by the government through the Intellectual Property Office of the Philippines. It is an exclusive rights granted for a product, process, or an improvement of a product or process which is new, inventive, and useful. These exclusive rights give the inventor the rights to exclude others from making, using, or selling the product of his invention during the life of the patent. A patent has a term of protection of 20 years, providing an inventor significant commercial gain. In return, the patent owner must share the full description of invention. Patentable inventions offer a technical solution to a problem in any field of human activity. However, theories, mathematical methods, methods of treatment, and artistic creations are non-patentable inventions. Patentable inventions, a technical solution to a problem in any field of human activity, dapat bago siya, dapat involve ang intensive step, and dapat industrially applicable siya. Ang requirements for filing a patent: first, request for a grant of patent; second, description of the invention; third, drawings necessary for the invention; fourth, filing fee. and the requirements for patentability, novelty, inventive step, industrial applicability. Industrial design. An industrial design constitutes the ornamental or aesthetic aspect of an article. A design may consist of three-dimensional features, such as the shape or surface of an article, or of two-dimensional features, such as patterns, lines, or colors. Industrial design are applied to a wide variety of products of industry and handicrafts, from technical and medical instruments to watches, jewelry, and other luxury items, from housewares and electrical appliances to vehicles, from textile designs to leisure goods. When an When an industrial design is protected, the owner, the person or entity that has registered the design, is assured an exclusive right against unauthorized copying or imitation of the design by third parties. That's all. Thank you.